there for a second. So today we're talking about the California eviction update. It's an update on the status of the California courts and the eviction moratorium. So in particular, we're talking about the COVID-19 Tenant Protection Act of 2020, which I call our roadmap through the end of the California eviction moratorium. And we're also going to touch on the federal eviction moratorium as defined by the Centers for Disease Control, the CDC regulations. So our last few webinars reviewed the new COVID-19 Tenant Protection Act of 2020, which we were calling at the time when it first came out, it was AB 3088. I'm going to call that our COVID Act, or the COVID Tenant Relief Act. We went through that in great detail and the changes that we observed back in September and October. But at that time, we had little knowledge of what practical effect that would have on how it would impact our experiences in court, how it would impact the services we were providing and our communications with landlords and tenants. And so since then, we took a little bit of a break from our webinars. We dove headfirst into our cases and our caseload. And now, 5 months later, we've got a little more perspective on the practical application of these new laws, and hopefully some insight for the rest of the year going forward. So the California eviction moratorium has some extensions. This week's news included extensions of both the California moratorium and the federal. So lawmakers announced from Governor Newsom's office and other elected officials in the California legislature, and they have an agreement to extend the eviction moratorium, specifically those restrictions imposed by the COVID Tenant Protection Act of 2020 through June 30th, 2021. So to put this in perspective, certain restrictions were supposed to expire on February 1st, on Monday. And once those restrictions are lifted, many landlords who have not been receiving rent would be able to move forward with evictions. So the extension of that February 1st date through June 30th means that non-payment of rent evictions might not be able to move forward until July 1st. It's also important to know that there's other pending legislation. AB 80 is the one that it proposes to extend through June 30th. AB 15 proposes an extension through December 31st, 2021. So we're pretty sure that the June 30th extension will happen. We don't know if there would be further extension. But we have a lot of folks who are just waiting for these restrictions to be lifted so that they can move forward with their evictions. Then the initial restriction on pursuing recovery of rent. So recovering the money that's owed to the landlord for that non-payment of rent was scheduled to proceed as of March 1st. Landlords would be able to go to small claims court to obtain a judgment against a tenant who had not paid the rent, but that will probably be extended until August 1st. But the good news is that the COVID Act allows landlords to go to small claims court and obtain judgments for that COVID rental debt that exceeds the $10,000 limitation. And they will be able to continue to do that just for the COVID related rental debt through July 1st, 2025. So California already had a pretty serious housing crisis, and that resulted in our 2019 Tenant Protection Act. You may recall that was the Rent Cap and Just Cause Eviction Act that became the law in January 1st, 2020. And we thought that was going to be the most difficult part of our job. But in fact, COVID happened, and now we have this 2020 COVID Protection Act, which built onto and uses a lot of that 2019 Act. And it's likely that we'll see some additional restrictions and new laws by the end of the year. There are, as I said, currently at least 2 bills. In fact, I looked it up. There are probably 6 or 7 bills relating to evictions that are already on the books for the 2021 to 2022 legislative year. So that federal eviction moratorium, they announced today the CDC order halting evictions, which was scheduled to expire initially December 31st. It was extended to January 31st. and now it has been extended through March 31st. And I will explain the difference between the California moratorium and the federal moratorium a little bit later in the presentation. It's also important to note that there will be federal stimulus money coming to California, and the proposal is that it would be used to create a renter aid program. They think that California will receive $2.6 billion, and the proposal at this time is to provide funds to income qualified tenants or their landlords in exchange for an agreement in which the landlord forgives some of that past due rent. Okay, so residential evictions, so these new proposed restrictions create a for-cause only eviction requirement. So with residential evictions, in certain areas, we always had to have good cause, but in other areas, we didn't always need good cause in order to proceed with an eviction. We could do a 30-day or a 60-day notice for no cause at all. And that is developing more and more to require for-cause evictions. So the new law's impact on the direction of residential evictions through 2025 is that it will probably require for-cause evictions almost across the board. Some of those restrictions will expire when, whether it's June 30th or December 31st, but that's the direction that things are heading. And the most immediate and biggest impact for evictions on tenancies from March 1st, 2020 through June 30th, 2021 is that portions of the new law will continue to affect the evictions requiring 15-day notices for cause through January 1, 2026. That's an extended date, assuming that all of the extensions that are proposed in AB 80 happen. Some of the restrictions will last through 2026. This means that evictions for COVID-19 rental debt in particular are mostly off the table until the June 30th or the December 31st date passes. So we're watching for that extension. And the definition of COVID-19 rental debt means unpaid rent or any other unpaid financial obligation of a tenant under the tenancy that came due during the covered time period. In order to fully understand what that definition means and what that term means, you have to have a certain number of certain statutes on hand and reference them regularly. So we have California Code of Civil Procedure, Section 1161. This is the old statute that we've always used for doing 3-day notices to pay rent or quit, 3-day notices for nuisance and waste, 3-day notices to terminate a tenancy based on subleasing. And the 1161 statute was recently amended by the CCP 1179 statute. That's the new statute created by the 2020 COVID Protection Act. And so the 1179 new statutes are important to note. And then we have California Civil Code Section 1946.2, B1 and 2, which are the just cause rent cap and just cause eviction statutes from the 2019 Tenant Protection Act. And you use that 1946.2 statute with adjustments made by the 1179 statute. And all three of these work together to know whether you can evict somebody. Okay, so what I like to do is keep a copy of the entire AB 3088 bill handy, because that bill amended at least 15 statutes. It amends or creates at least 15 statutes relating to real estate and or evictions. And then you also have to keep on hand a copy of California Civil Code Section 1946.2. So the way that AB 3088 has created these new statutes, it defines certain reasons why we can evict people for cause. First of all, the first bullet point is whether a tenant was guilty of unlawful detainer before March 1st, 2020. So that means that a notice was served on a tenant prior to March 1st, 2020. That notice expired prior to March 1st, and At that point, the landlord could have gone forward with an eviction, but for some reason they didn't. These are very rare, although we have had one. And if the landlord has not proceeded with an eviction with a notice that's that old, they probably have waived it by now. So those are pretty rare. The second bullet point are the for-cause evictions for non-payment of rent. And these are pretty weak cases. The reason that these are weak is because, so during COVID, you serve a new notice to the tenant demanding the COVID-19 rental debt as defined, and then the tenant failed to comply with the requirements of 1179.3. That means that the tenant failed to submit the declaration. When we serve a notice to pay rent or quit now, because of the new laws, it has to be a 15 business day time period, and you have to accompany it with a declaration. And all the tenant has to do in order to comply with 1179.3 is sign the declaration and return it to the landlord or file it with the court. So this is a very weak way to proceed with an eviction, because at any point, if that declaration is submitted to the court, I'll explain later in the presentation, it could cause your whole case to be dismissed. And I don't like to set up a case with a client where, you know, we might fail for a very simple reason, where it's very easy for the tenant to get the case dismissed. I like to have a much stronger case than that. So the third bullet point is really where most of our cases are falling. And these are unlawful detainer cases that arise because of termination of a tenancy based on an at-fault cause or a no-fault just cause as defined in Civil Code 1946.2 B1 or 2, with some adjustments to those definitions. And don't freak out, that sounds like a lot of legal mumbo jumbo. I'm going to explain. So I've got two slides here. The first one is the at-fault just cause definition. All the reasons why we can do a 3-day or a 15-day. For the most part, we're doing 15-day notices. The second slide are the no-fault just cause definitions, where we are able to do a 30 or a 60-day notice. So for nuisance or waste, we're getting a lot of requests to do these. And the advice that I give for a landlord who wants to do a 3-day notice because the tenant is creating a nuisance or they are laying waste to the property is that there's a very high threshold of proof required for a nuisance or waste eviction. And it's really up to a judge or a jury to decide where that threshold is. Most of the case law that you look up for nuisance cases relates to illegal activity, gun violence, animal violence, dealing drugs, that sort of thing. So if you have proof that something very serious is going on, nuisance is the way to go. If it's more like a noise violation or somebody streaking through the hallways, those are harder to prove. And then waste is something more than just the tenant messing up the landscaping. You know, it would be something more like an explosion happened, or, you know, they had a meth lab and an explosion happened, or they're knocking down walls, they're destroying parts of the house. So then for a 15-day notice, we might be able to evict a tenant for expiration of a fixed term lease. But the new law requires the landlord to make a written request to the tenant to renew the lease, and then the tenant has to refuse to renew the lease. So if that procedure has been done, you may be able to use this as a reason to evict, but it's pretty rare, because if you want the tenant out, why would you offer them a new lease? Criminal activity is a good way to prove nuisance, but it's also a separate bullet point under 1946.2. If a tenant refuses to allow the landlord entry into the premises because of, you know, there's a flood, there's an emergency going on, the landlord needs to enter with a contractor, or the landlord is trying to show the property for sale, or a variety of other reasons why a tenant landlord might want to get into the property. If the tenant refuses, the landlord should have some witnesses to explain how the tenant refused to allow entry, and then would be able to proceed on an eviction for that reason. Use of the premises for an unlawful purpose, we've kind of already gone over that one, but an unlawful purpose could be a variety of other things besides criminal activity, nuisance, or waste. If an employee refused to vacate premises after they've been terminated, we could evict, but we look for a nexus between the tenancy and the employment. So, there's a lot of documentation of employment. If the landlord does not have that documentation, then we probably can't proceed on that basis. Nannies who are working under the table, getting paid under the table, it becomes difficult to prove that their tenancy was related to their employment. Sometimes a tenant announces that they are going to move out. And, maybe they send a text or an email saying, I'm moving out on the 30th. The landlord relies on that. If the tenant fails to move out, then we can use that written notice that the tenant provided to the landlord to evict the tenant. Although we also like to confirm in writing so that we have more than just a text message or an email. Okay, so then we have the no fault just cause definitions. These are other reasons why we may be able to proceed with an eviction. But these would be a 30 or a 60-day notice. 30 if the tenant has been there less than 1 year, 60 if they've been there more than 1 year. So if the owner wants to occupy the premises, or their spouse, domestic partner, children, grandchildren, parents, or grandparents would like to occupy the premises, we can do a 30 or 60-day notice. And if the tenant fails to move out, we can evict. Also, if the owner has withdrawn the property from the rental market because they're selling it to an individual who's going to reside in the property, this could be a basis for eviction only if the property has been in escrow for 180 days or less. The buyer is a bona fide purchaser purchasing the property for fair market value. That means it's an arm's length transaction. It's not a sale to a business associate or family. So a bona fide purchaser, fair market value, and as I mentioned, the buyer has to intend to occupy the residence. Also, the seller, the owner, cannot be a corporation. We may be able to evict based on an order by a government agency or a judgment relating to habitability, an order by a government agency ordering the tenant to vacate or the premises to be vacated, a local ordinance that necessitates vacating the premises, and similarly, if a substantial remodel must occur, it is defined in the statute how this must occur, like a substantial remodel in order to bring the premises up to habitability or up to code. We may be able to make a case out of those reasons. Okay, so let's go back to those COVID-19 rental debt evictions, because these are, this is the big deal that's going on right now. When are landlords going to be able to get these non-paying tenants out? When are we going to be able to collect from these non-paying tenants? So for the most part, as I said, we are not proceeding with these evictions because they're very weak cases. So for non-payment of rent from March 1st, 2020 through now June 30th, 2021, whenever we serve the 15 business day notice to pay or quit, it's accompanied by a notice from the state of California and a hardship declaration. California requires us to serve all three of those. And the notice from the state of California informs the tenant that they may maintain possession of the premises by paying 25% of the rental debt. But even if they don't pay the 25% during the, prior to the expiration of the restrictions, so prior to June 30th, even if that tenant does not pay any rent at all up to June 30th, we still can't evict them in the meantime. We still have to wait until July 1st. And then if they pay 25% of all of that past due rent on June 30th, then we won't be able to use any of that as the basis for an eviction on July 1st. My advice is that if you're seeking to evict someone for non-payment of rent, you wait until July rent is due and issue notices all along the way. So every month that rent comes due, or every couple of months, you issue a new 15-day notice, you let it expire, and then once the July rent is past due, you issue a new 15-day notice for that rent and anything prior, and then you proceed with the eviction. And that, to me, is the strongest case that you can make and the soonest possible deadline. Okay, so if the tenant fails to provide that declaration, the law states that if the tenant fails to provide the declaration, then you can proceed with eviction even prior to June 30th. I don't recommend doing that unless you're absolutely desperate to do it, because the tenant can provide the declaration to the landlord prior to eviction, but they can also provide it to the court at any time during the unlawful detainer case. And I'll explain in a moment what effect that has on the case, because it can cause the entire case to be dismissed. And again, the 15-day notice to pay or quit is 15 business days, so it's actually more like 20 or 21 days. And as a thank you for attending today, and we're not done, but I'm just letting you know that we will be providing you with the updated notice from the state of California, the updated 15-day notice for rent due during the transitional time period. So that's from September 1 through, I guess, June 30th. And then the California declaration, because all of the notices that we've been using will have to be updated when the extensions occur. So when the new laws pass, probably this week, we'll update our notices, and then we will send them out to everyone who attended today in a Word format, because if you are brave enough to try to serve your own notices, at least you'll have the most updated ones. However, we do recommend that you have an attorney draft the notices for you, because it is really tricky, especially right now. It was tricky before, it's especially tricky now. We're also using 30 and 60-day notices for no fault, just cause reasons, and other notices may also be required. These are not the only notices required. There may be several others. Most of the time when we're serving non-payment of rent notices, and when we're serving any notices at all, there's usually 4 or 5 separate documents that we are serving. All right, so once we get the notices out and the timing expires and we feel confident that we can proceed to court, there are pretrial procedures that we have to follow. And recently, almost every form that we use has been updated. We use the Judicial Council forms. There are also some local forms. There's a new local UD case cover sheet that I believe we're supposed to use, although I think the plaintiff's mandatory cover sheet and supplemental allegations may cover everything. So this plaintiff's mandatory cover sheet and supplemental allegations is a statewide Judicial Council form. It's about 3 pages long, and it goes step by step through all of the COVID tenant protections. It's written so that the clerk can scan it and decide whether you're allowed to move forward with your case or not. If you fill it out in a way that the clerk is trained to reject, they will reject it over and over again. And you do have the right to go into court and ask the court to allow you to proceed because you think that the clerk is wrong. I tried that, it didn't work. The judges are standing behind their clerks and the training that they've been provided. So then the standard UD 100 complaint form, which is a Judicial Council form, was also updated as of September 2020. It now includes references to all of the 2019 Tenant Protection Act, rent cap and just cause eviction issues. Those are the AB 1482 issues. The at fault and no fault just cause eviction information has to be included in your complaint. And then we have a new writ of possession form. Okay, so I promised to explain to you what's the difference between the California Hardship Declaration and the CDC Hardship Declaration. We are getting both of those served from tenants, and the effect that they have on your case is drastically different. So it's very easy for a tenant to claim protection under California Hardship, All they have to do is show loss of income caused by COVID, increased out-of-pocket expenses relating to COVID, increased expenses directly related to health impacts of COVID, caring for a child, elderly, or disabled or sick family member directly related to COVID, increased cost for caring for the sick family member or caring for your children, and other circumstances relating to reduced income or increased expenses. I will add that subleasing is protected in California because of the way that the statute is written. And then in the declaration, the tenant also has to include this blanket declaration that any public assistance they've received didn't make up the difference for the rent. So the California declaration entitles the tenant to an immediate hearing on the issue of hardship and whether the case may move forward. The hearing shall be held with 5 to 10 days notice, and it shall be prior to trial. So the other rule that plays into this is once your case is at issue, you file the case, the tenant has responded, you request to set the case for trial. The plaintiff files a form with the court requesting to set the case for trial, and the court is obligated to set the trial within 20 days of the request. So during this time, the tenants are very likely to request a jury and to submit their hardship declaration. And during this time, the courts are trying to get these COVID hearings to happen. So if your tenant submits the declaration to the court and the court schedules this COVID hearing, the next step is that the court gets to decide whether you're allowed to proceed. If the tenant shows that they have a COVID hardship, and it doesn't take much, they just have to stand in court and say, I have greater expenses due to COVID, then your case gets dismissed. And you don't have to pay any attorney's fees, and you don't have to pay any filing fees for the tenant. They're not the winner of the case, quote unquote, but your case does get dismissed and you'll have to start all over when the COVID restrictions are lifted. The difference between that California declaration and the CDC declaration is that the CDC declaration does not entitle the tenant to have this separate pretrial hearing to determine whether the plaintiff gets to move forward. Instead, the CDC declaration creates a bunch of issues of fact that it is the tenant's obligation to prove at trial. So it adds all of this other information that the tenant has to bring to trial to prove one of the following: whether they have acted in their best efforts to obtain available government assistance and make partial payments, whether they have income less than $99,000 for a single person or $198,000 for a couple, whether they've had substantial loss of household income, or whether they are likely to become homeless or go to a homeless shelter if they are evicted. The CDC states that its rules do not apply if you are in a state where the state law is more protective than the federal law, but these laws look like apples and oranges. It's hard to look at the two and say that one is more protective than the other because they are very different. Both of them currently say that when the moratorium is ended, the tenants still owe all of the past due rent, fees, penalties, and interest for unpaid rent. However, the new California proposal, the AB 80, seems to indicate that you won't be allowed to charge fees or penalties or interest for unpaid rent. So if that one passes, there will be some changes. Okay, so the fun part are the virtual trials and jury requests. We've had some exciting hearings lately. We had a virtual trial where our client was actually in Morocco and was able to appear virtually. But he couldn't get here from Morocco. He booked his flight, but because of COVID, the Morocco airport shut down. He got a little cold. He didn't feel comfortable flying, and there just was no way he could get here. But we did manage to hold this trial with our client in Morocco. He called in by phone. The virtual trials are mostly proceeding through Microsoft Teams, That's generally what the court is using. They're set up very well to hold trials that way. And my rule, which I created since I've started doing virtual depots and virtual evidentiary hearings, is that I make sure to get a hard copy of all of my evidence in the hands of all of the parties and the court at least 4 days prior to the hearing or prior to the deposition. It is really difficult to present evidence if you are trying to display a document on the screen and then question a witness about it, because a witness has to authenticate the document. They have to say, yes, I recognize this document, it is such and such, and then they have to read what's on it. When you are presenting a document on a screen, in order to read it, you have to zoom in. And in order to look at the whole document and identify what it is, you have to zoom out. And it's the zooming in and out and scrolling up and down that really takes a lot of time. It's extremely confusing. So what I have done is use hard copies in the hands of everyone, and then I question the witness, and I can see the witness and look at their face instead of having to look at a document. Also, jury requests are very popular. It's a very popular tactic by tenants. If the tenant is knowledgeable about how to request a jury. So a lot of people represented by legal aid are doing this. It's a great way to delay, because currently we are not doing any juries. Due to COVID, there are not juries happening. Maybe a couple for criminal, but for evictions, there are no juries, and we don't know when they'll proceed. It could be 6 months. It could be sometime in 2022. So it's a very effective delay tactic. The way this works is that when the plaintiff requests to set the case for trial by filing a form and serving it on all the parties, then the defendant has 10 days, 5 for service by mail, and then 5 days to file their own form. It's actually the same form, requesting to set the case for a jury trial. If they miss that 10-day cutoff, then the court may deny the jury, but it's up to the judge's discretion. And they are supposed to allow for the jury if they can. The strategy, if a tenant is granted a jury trial, is that then the plaintiff would want to file a motion for summary judgment and cross your fingers and hope that you can prove your case on paper and that a judge will give you the eviction judgment from just a motion for summary judgment. Otherwise, you got to wait until jury trials go forward. Enforcing judgments for possession of the premises. What we normally do with UDs is we get the judgment for possession. We enter the judgment because it's faster. If it's just for possession and not for money, it's faster to get it through the procedures and then get the writ of possession and then get to the sheriff lockout. So when you have a court judgment after trial, it takes a little bit longer because there's an extra step of getting the judgment from the courtroom down to the clerk, issuing the writ, and then getting it over to the sheriff. When you get a default judgment by the clerk, you've got a quicker turnaround time because there's no trial, and there's the courtroom doesn't really have anything to do with that procedure. But sheriff delays have been very unpredictable. There have been at least 2 times in the last year that the sheriffs had a long pause in their enforcing of writs of possession. And it's not in the public eye when this is happening. We don't get any announcement that they are not going to be enforcing lockouts. They just stop, and then we find out when we ask them to do a lockout that, oh, those are on hold for now. They also don't really announce when they start them back up again. So currently they've started again. They took a long break over the holidays, a couple of weeks, and as of last week, I believe they started doing them again. All right, so a couple of other notes, and by the way, I have by no means gone through all of the new laws and all of the new changes. I'm just focusing on getting the judgments for possession. But remember that landlords will be able to pursue the non-payment of rent in small claims court We believe that will start July 1st, 2021. You'll have until 2026 to continue to pursue that. There's a 4-year statute of limitations because it's a breach of contract claim. And we believe those will start to be available, those judgments will start to be available August 1st, 2021. The tenants still owe all of the rent. Then on the other column, retaliatory evictions, also be very aware that the new laws are strict about making sure landlords are not retaliating against tenants for non-payment of rent. I understand that a lot of landlords are hurting because they haven't been receiving the rent and they have been paying the expenses of the property and trying to keep up with mortgage, property taxes, insurance, and all of those expenses. But it is very important not to retaliate. It will hurt you, and there are punitive damages available to the tenants if they can prove that the landlord has retaliated. And that restriction goes through currently 2025, but it will be extended to 2026. So just keep that in mind. All right, so